Good afternoon, everyone, and thank you for joining us today. My name is Ali Schulman, and I'm the Manager of Marketing and Communications here at the SFIA. I'm excited to welcome you all to today's webinar, Back to Work in the COVID-19 Era, Concerns for Employers and Real-World Best Practices. Today, we have 4 lawyers from Norton Rose Fulbright joining us, Mario Barrera, Eddie Lewis, Jamila Mensah, and longtime member of SFIA Legal Task Force, Kevin Mayer. As you all know, it seems that we can see the light at the end of the tunnel. The first shipments of the COVID-19 vaccine have gone out, and Americans have already begun receiving the vaccine across the country. While the last 10 months have been unprecedented and unpredictable, the next several months will sure follow suit. Many Americans quickly transitioned to telework to protect Americans from the rapid spread of COVID-19. As more people get vaccinated, the opportunity to return to the office will present new challenges. Are vaccines mandated? Should they be mandated? When is it safe? What office protocols should be enforced? To answer all of these questions and more, we have Mario, Eddie, Jamila, and Kevin here. Remember, we will be doing a live Q&A following the presentation. There is a question bar on your screen where you can submit questions to us all throughout the presentation, and our presenters will answer them once they're finished. Also, just as a reminder, the webinar will be recorded, so if you wish to access the presentations and its slides after the webinar, you will be able to do so through our website. And with that, I would like to get things started and turn it over to Kevin Mayer.
Thank you so much, Ali. Hello, everyone, and thank you for joining our US OSHA team today for a discussion on return to work protocol and best practices for the health and safety of your employees. I'm Kevin Mayer, a partner in our Los Angeles and San Francisco offices. I'm a product liability and OSHA trial attorney and a founder of the SFIA's legal task force, having been involved with the SFIA for well over 25 years. In our OSHA practice, we advise our clients in connection with regulatory compliance, internal audits, incident investigations, witness interviews, and citation appeals and administrative law trials. We've been counseling our firm's clients on workplace health and safety issues pertaining to COVID-19 since the outbreak of the pandemic. I'm pleased to be joined today by Jamila Mensah, a partner in our Houston office. Jamila's practice covers all areas of employment law. She represents clients in federal and state court and before administrative bodies, including the Equal Employment Opportunity Commission, the Department of Labor, and OSHA. Jamila counsels employers on a wide range of labor and employment issues, including hiring, termination, wage and hour compliance, disability accommodation, employment discrimination, and the drafting of employee handbooks and personnel policies. We're also joined by Mario Barrera, a partner in our San Antonio office. Mario has more than 25 years of experience litigating and trying cases to verdict. Mario is board certified in the area of employment and labor, and his specialties include discrimination, harassment, retaliation, wage and hour, collective bargaining, and OSHA. And specifically with regard to OSHA, he advises clients on compliance, incident investigations, and citation appeals in a variety of industries. Finally, we're pleased to be joined by Eddie Lewis, our United States Head of Environmental, based in our Houston office. Eddie's OSHA practice ranges from providing regulatory compliance advice to personally responding to the scenes of industrial incidents, to work with OSHA and other regulatory authorities. In his prior professional life, Eddie worked as a chemical engineer, which contributes, of course, to his extensive knowledge of technical issues and industrial processes. His practice frequently involves legal issues in which catastrophic incidents and complex technical matters are at the forefront. Now, it's important to understand that everything that we say today in our webinar is opinion. We are not specifically dispensing legal advice, and listening does not establish an attorney-client relationship. You should not quote the speakers without our express written permission in advance. If the press is listening, you may certainly contact us and we may be able to speak with you on the record. So I'd like to first introduce Jamila to talk about some of the specific issues that employers are now confronting in the labor and employment arena having to do with COVID, and notably with regard to the distribution of vaccines. Jamila.
Thanks, Kevin. So we're going to talk a little bit this morning / afternoon, try to get the slides. There we go. Get to the first one. About some COVID-19 screening and preventative measures. You know, it's interesting to talk about this topic now because even as recently as yesterday, we got some new guidance from the government on how to deal with COVID-related issues, specifically as they pertain to vaccines. And we'll talk about that in a moment. But a lot of you, if you haven't already, either in your own organizations or in others, have come across employee screening. And the goal of employee screening is to reduce the risk of employees contracting or spreading COVID-19 within the workplace. And screening takes on all shapes and formats, but most common are temperature checks, whether those be at home or at work, or employee questionnaires. And the idea here is to assess the risk. If you're going to implement any sort of screening mechanisms, you want to balance the need to obtain what is essentially private employee health information against the threat that's posed by the virus and the requirement to keep the workplace safe. Employee screening, again, has been implemented in various forms and fashions over the last several months. And some considerations really fall under the guidance that we've gotten so far, whether it be from the EEOC or under HIPAA or other laws or guidance. And so the EEOC has already declared that COVID-19 meets the ADEA's direct threat standard, which allows for more extensive medical inquiries and controls. So under normal circumstances, when we're not under a direct threat sort of circumstance, the EEOC and other organizations, federal organizations, require or only allow employers to take very limited medical information or make very limited inquiries with regard to the medical information or history of their employees. But under this direct threat standard, we're clearly in a crisis, and so a lot of those requirements have been lessened. The EEOC guidance up till now has stated that it's permissible to take employees' temperatures and to ask if they have symptoms. So again, you likely already have these measures implemented at your organizations, and even if you don't, you have been somewhere either to visit a doctor or to go to the dentist where these screening measures have been taken. Likely your temperature is either taken when you show up at the door or you're asked to report your temperature before you arrive. So some of the issues that arise just with the screening, in addition to just sort of getting adjusted to this new way of being, there are some wage and hour issues, whether or not the time an employee spends screening or being screened is compensable or non-compensable. And this is similar to when you think about the activities that an employee may undertake before and after clocking in. For example, at certain jobs, whether the bag check in a retail establishment is compensable time, it's the same sort of additional work-related activity that needs to be, a determination needs to be made as to whether it's compensable or not. And generally, clients are treating this as compensable time in that it occurs in alignment with or at the same time as clocking in for most employees. So that's something to think about. HIPAA and the employee confidentiality concerns are actually a bigger concern, or actually more common concern, regardless of the nature of the employee's employment, whether they're hourly or salary. Because here we're talking about actually obtaining, recording, and possibly maintaining personal health information. And we know that can all be very tricky. But again, the EEOC, the guidance allows for some leeway here in recording temperatures. The idea is that you don't keep the information in the file or give access to it to anyone who shouldn't have it, the same as you would any other medical information. You want to be careful if you're going to be doing the screening yourself, thinking about what materials you use. Most people with the thermometers or who are taking temperature are doing the no contact. A lot of times it's a no contact, and then it's recorded either in a log or with a sticker that the person can put on their shirt or some other way to tell that the person's temperature has been screened prior to going into the workplace. But the key thing to remember here is to try to maintain the confidentiality of the health information as best as possible. And usually, especially as it pertains to temperatures, there's no reason to keep that information on a day-to-day basis. You can easily dispense of it once you've taken the temperature and moved on to the next day, since it's something you have to do every day anyway. Just a bit of a lag in the slides. Oh, there we go. Okay. So now we'll talk a little bit about the mandatory vaccine. And so as I mentioned before, I'm going to go back on the slides. As I mentioned before, the EEOC just issued guidance. And so in turning in in between the time that we turned in the slides to Allie and the time that we did this presentation today, we already had new information from the EEOC about what we can and cannot do as it pertains to vaccination. So just a little bit of background on vaccines as I try to get us back to the proper slide. Historically, there's only been a couple of other instances where vaccines or mandatory vaccinations have become an issue in the workplace, and that has been in really massive outbreaks of the flu, for example. And so as a result of that, only the medical industry typically provides the best example for what people can do when mandatory vaccines are required. Healthcare and childcare, for example, most healthcare facilities require mandatory vaccines of some type already, as do a lot of childcare providers in schools and school districts. A mandatory flu vaccine is the closest example for comparison in terms of how this issue is going to be handled. And even before yesterday, there was already some indication that the agencies are going to support a mandatory vaccine under certain circumstances. And so again, as we talked before, the EEOC has already decided that COVID-19 poses a direct threat. And even OSHA, the guidance suggested, again, prior to yesterday, that they would likely defer to employers if employer chose to mandate the vaccination. And they were actively encouraging their own inspectors to get the vaccination as soon as it became available. And so yesterday, the EEOC issued its guidance, and really they just added to their ongoing COVID-19 related guidance that they've already put out. And they essentially went through exactly what we have here, which are sort of the risks and ability or rather the risks and considerations to take in mind when deciding whether or not to mandate a vaccine for your employees. So generally, the EEOC's guidance, which is in line with what the statutes have already said, is that employers are required to provide reasonable accommodations under certain statutes, regardless of what the circumstance is, and that those accommodations or that obligation to provide an accommodation applies in the vaccine context. And so the potential risks under the ADEA are that individuals with a disability may not be allowed to or may not want to take the vaccine based on their disability. Prior to the only courts I've ever dealt with this issue dealt with it as it pertains to a flu vaccine, and the courts were split as to whether or not a physical sensitivity or an allergic reaction of some sort to vaccinations would constitute a covered disability. But also, the law hasn't changed, and the EEOC reiterated this yesterday, that accommodation, the employer must consider an accommodation, whether that means an exemption from the vaccine altogether or the ability for the person to work from home or some other way to accommodate an individual who cannot take the vaccine because of a disability, unless providing such an accommodation creates an undue hardship. And the additional guidance that the EEOC provided on that piece is that even if an accommodation cannot be made, maybe an accommodation does actually create an undue hardship, the employer can prohibit the employee from coming on to the site, to the work site or to the employer's facility, but it cannot automatically terminate the employee because they won't get the vaccine. There are still additional steps that have to be taken before a determination is made as to whether or not the employee can continue to work for the organization. And this is the same for the religious discrimination claims under Title VII. The employer has an obligation to accommodate a sincerely held religious belief, and that is language, that's a term of art that the courts apply when they're deciding religious accommodation cases. Personal anti-vaccination positions are generally not sufficient to meet this standard, and nothing in the guidance yesterday from the EEOC changed that or broadened that in any way. The guidance simply just walked through the accommodation process for religious claims the same as they did for disability claims. Another note under the ADA on the vaccines from the guidance yesterday is that the process of receiving a vaccine is not a medical exam for purposes of the ADA, so it doesn't have to meet that standard. But employers do need to be careful about what questions they ask an employee prior to giving them a vaccination. In other words, the pre-vaccine questionnaire, you need to be careful because that can, depending on the question, constitute a medical exam and be have a standard higher under the ADA. And generally, same as with the screening we talked about before with taking the temperature and those things, you have to be mindful of what questions you ask and how you maintain the information in order to protect the employee's health information. And then just some considerations, even though we now have a vaccine, there's still a decision needs to be made as to whether or not it actually makes sense for mandatory policy, whether that's truly necessary. You have to consider some alternatives, maybe continuing remote work or extending it for certain people, always physical distancing and facial coverings. Even though we have a vaccine, as you've heard in the news, there's some people who are still resistant to the idea of taking it, even outside of the accommodation issues. Maybe they don't trust the science because it happened too quickly, or maybe they just don't trust science, or whatever the issues are. And so be prepared to face some of that if your organization decides to implement a vaccine policy. Also, determining whether or not you issue the vaccine yourself, or you get a third party, or just get the person to go get it somewhere else and then bring proof that they've been vaccinated. That's probably the most efficient way to handle this. It can become very messy for non-medical entities to do things like administer shots. Maybe you bring in a third party the same as you would to administer flu shots. I suspect this one may be a little more complicated given the timing and the amount of vaccine available. So something to think about as well in terms of just the logistics of implementing such a policy. And then also, to keep track of legal developments, because as we've seen, these things literally change by the day. So that's just a little bit about where we are in terms of screening and vaccines. And now I'll pass it on to Mario.
Thanks so much, Jamila. So now we're going to talk a little bit about the overarching regulatory scheme of the Americans with Disabilities Act and how that interacts with certain considerations that you may confront. Mario.
All right, thanks, Kevin, Jamila, and good morning and good afternoon, everyone. I'm going to go through this as quickly as I can. Basically, I'm going to cover the Equal Employment Opportunity Commission, the Department of Labor. I'm going to start with the DOL, and we're going to get into some tips, and then I'm going to get into some questions and answer scenarios, and then we're going to go sort of finish up from the EEOC perspective. So starting with the DOL, they issued 2 FABs, Field Assistance Bulletins, numbers 5 and 6 regarding, compensable time for teleworkers, and then the seasonal businesses that we're going to get into, which I think are very applicable to the SFIA. Most of us have had a lot of experience already, 9 months, 10 months of telework. Some of us have gone back to work during the summer and then had to come back and work remotely and then have returned in the fall. There's been kind of all variations, but the long and short of it is that, and the arrows are not, let's see here, there we go. Let me go back here. Okay, so bottom line with regard to the DOL's position is, if as an employer you're aware that hours were worked, you didn't authorize it, but you're aware of it, you got to pay for it. The only thing that allows you to sort of is an escape is if you didn't know about it and you had no reason to know about it, and we've gone ahead and given you a Fifth Circuit decision there from 1995 that continues to be sort of the case precedent on that point. So the telework hasn't really changed much. If you're going to want to limit the amount of overtime that is worked or the hours worked, then you've got to be proactive and make sure that your employees are aware of it. So I think the key is your timekeeping systems. Are they user-friendly? Are they accessible? Obviously, the more, the better, because it reduces these claims, and the onus then becomes upon the employees to make you aware of it. And I think the key thing is number 4, if you want to avoid your employees working overtime, then you need to make that known. You need to let them know. And obviously, don't go overboard with surveillance when it comes to this. But I think most employers have kind of gotten the hang of telework responsibilities, at least with respect to the DOL's perspective. All right, the seasonal businesses, amusement parks, golf courses, stadiums, NFL, Major League, the NBA. We all saw how the NBA responded during the bubble. We've seen Major League Baseball, and now we're in the middle of the NFL and games being canceled left and right. Obviously, COVID continues to be an issue and will continue to be in the months to come. So the FLSA has an exemption for seasonal businesses and businesses that have been creative and created sort of alternatives to what they used to do before. You're not going to lose that exemption. And that's very clear from the DOL bulletin number 6, as long as you kind of meet these points that are laid out there, especially you're paying them at the same wage level and rates that they received. Now, Obviously, once you discontinue that, then you've got to move forward to the way it used to read. But the DOL is even cognizant of the fact that 2021 may still be impacted by COVID. So we're going to continue to see this as sort of a changing model. All right. So what does the EEOC have to say about this? They too issued guidance back in June, and then they updated in September, really dealing with reasonable accommodations and telework considerations. Again, so let's go ahead and look at the ADEA, what Kevin and Jamila talked about, the Americans with Disabilities Act. We all know there's got to be an effort to provide a reasonable accommodation. There's that interactive process. Unless the accommodation that's being requested, and of course the employee does not choose the correct accommodation or the proper or reasonable accommodation, that's up to the employer. But unless there's an undue hardship, then you've got to proceed with that interactive process and come up with an accommodation. So you're going to see this, obviously, we've seen many requests for accommodations in the last 9 to 10 months, and we're going to continue to see more of them. So, here's a couple of questions that I thought would be interesting to raise. So if an employer requires its employees to telework because of COVID, is the employer required to provide a teleworking employee with the same reasonable accommodation that it provides to its individual in the workplace? And the answer is not necessarily. If the request is made, the employer and the employee should get into that interactive process to be able to see what kind of an accommodation can be brought up, but it is not a requirement. Here's another question. If an employer has its employees telework for the purposes of slowing or stopping the spread of COVID, does it automatically have to grant telework as a reasonable accommodation to every employee with a disability who requests to continue this arrangement after the workplace is reopened? The answer is no. Here's a third question. Assuming this advances. There we go. Assume that prior to the pandemic, an employee with a disability had requested telework as a reasonable accommodation, but you as the employer denied it because of concerns that the employee would not be able to perform the essential functions remotely, and the employee therefore continued to come to the workplace. However, now once COVID hit and it subsides and the temporary telework ends, the employee renews his or her request for telework as a reasonable accommodation. Can the employer again refuse the request? And the answer is, it's gonna sort of depend on the situation. All right. The temporary excusing of performance of essential functions. It does not mean that the employer has permanently changed that aspect of an employee's job description. So it is really clear that those changes are not required. All right, here's another question. Is an employee entitled to an accommodation under the ADEA in order to avoid exposing a family member who is at a higher risk of severe illness from COVID due to an underlying medical condition? And the answer is no. And there we go. All right, and then the last question I wanted to raise under the EEOC is, an employer is concerned about a particular employee's health because the employee is at a higher risk for severe illness if the employee gets COVID, but the employee has not requested an accommodation. Can the employer refuse to allow the employee to return to work? And the answer is no. The ADA does not give that employer that right. All right, so going beyond the reasonable accommodation, I think it's important to remind everyone what the EEOC and some of the related sort of alphabet statutes that as I refer to them, prohibit. All right, you can't prohibit your older workers from coming back to work because you fear that they're more prone to getting ill, and so you want them working remotely at home. If they want to return to the office, you can't discriminate on the basis of their age. The same thing is true for pregnant workers. All right, just because they're in a high risk category does not mean that you as an employer can take on a paternalistic role and say, no, you're going to continue working remotely from home. You're going to run afoul of the Pregnancy Discrimination Act as well as Title VII. And then finally, politics has obviously been at the forefront of 2020, and we saw so many pejorative terms used in reference to COVID and the pandemic. And obviously, there's been a huge spike in discrimination allegations and charges of discrimination filed by people of Asian descent. simply because of the origins of where this pandemic arose. And so you have to be careful and make sure that your employees are aware of your EEO policies. So as we sort of wrap up, how do you best talk to your employees about returning? All right, if they're expressing any kind of concern or fear, make sure you understand what's prompting those reasons. If they're requesting accommodation, remember the ADA. You've got to engage in an interactive process. You can look at modification of work schedules, hours of operation. You can even look at the issue of furlough and severance, all of which were very hot back in the March, April timeframe. Monitor the case numbers in your local municipality on a daily basis, and just avoid making anything that could be construed as an arbitrary decision. And so the key takeaway here is employers should always explore all options for implementing safety measures, all right? Proactively evaluate all the positions for which you think on-site work is an essential function. Make sure you've got that as a backup and you can prove it to the EEOC or to the Department of Labor. And you should be wary of asking employees whom they have identified as vulnerable to stay at home to reduce the risk of COVID. Again, not taking a paternalistic approach. So we've covered a lot of material in a short time, but I know that we got Eddie to bring up the rear. So I'm going to turn it back over to Kevin and to Eddie.
Thanks so much, Mario. So now, ladies and gentlemen, we're going to talk about what happens when OSHA comes calling, specifically with regard to COVID. And this is particularly important in light of the fact that certain jurisdictions have now adopted so-called emergency temporary standards specific to the employment, workplace, and COVID. Eddie, thanks so much. Eddie, you may have muted yourself.
Okay, can you hear me now? Okay,
Yep.
Sorry about that. I'll move through the material very quickly. Some of the states have adopted standards at the federal level. That is not the case. So in terms of what laws apply to employers, there have been efforts made to force OSHA to adopt standards. Those have been unsuccessful. As a result, the standards that apply are pre-existing standards that already existed on the books with OSHA and the general duty clause. Beyond that, OSHA has issued quite a bit of guidance to tell employers what it expects, and almost undoubtedly all of the folks on this the webinar have read some of the guidance, develop plans in accordance with that guidance, and that tails into helping you to comply with the general duty clause. I have here on the screen a list of some of the pre-existing standards that OSHA adopted that are specifically applicable to COVID-related issues. For the folks on this call, probably the most important of these relates to the record keeping and reporting requirements, and I will address those in just a moment, a little more detail. As far as the general duty clause itself, this is a statutory requirement that exists for any purpose. If you are going to employ someone, and it doesn't, there's not specific OSHA standards involved. OSHA, basically, employers are required to furnish employees with a workplace that is free from recognized hazards that are causing or are likely to cause death or serious physical harm. OSHA's made clear in various publications that it will consider bringing general duty clause cases against employers based on COVID, and it's done so in a few cases already. There are 4 required elements. You can see them on the screen. A hazard has to exist in the workplace. As it relates to COVID, someone's probably going to have to be infected and probably have to face death or some other very bad physical outcome as a result of the COVID infection. The hazard has to be recognized. It's going to be hard to think that's not the case in the world we lived in 2020. The hazard has to be likely to cause death or serious physical harm. I think this would have been a very interesting legal issue. as to whether it is likely whatever outcome may have occurred was likely to occur. So there may be a defense there in the event that someone were to receive such an allegation and decide to contest. And then finally, and this is the heart of why OSHA would bring such an allegation, is there has to be a feasible and useful means to correct the hazard, that something could have been done to prevent the illness. In terms of guidance, I made reference, there has been a lot of guidance. In an effort to be succinct, we'll summarize and say what the plans would encourage folks to develop plans. It's a good idea, it's going to be useful for the general duty clause, but to think carefully about the words in the plan. No good deed goes unpunished. And if there is language in the plan that is absolute, when in reality there are discretionary occasions that may occur, there may be reasons to have a caveat, some type of an exception or an out, then write that into the plan so that there is greater flexibility. That may protect both in terms of personal injury lawsuits and an OSHA enforcement action. I think the most important things from this slide in terms of what we've seen with some of OSHA's pronouncements, Jamila made reference to it from the EEOC point of view, but in terms of the temperature screenings, you don't have a medical record unless you have some type of a medical professional administer the temperature screenings, and that's a reason probably not to do so unless you have a good reason to do so, because if you do and you keep those records, then you have to keep them for 30 years. And there's all sorts of requirements that are going to apply as a result. Let's see. OSHA's developed industry specific for retail workers and guidance. Looking at the record keeping and reporting obligations specifically, these are OSHA 300 and 301 logs are how OSHA expects employers to tell about fatalities or hospitalizations. How do you know with a COVID hospitalization of one of your employees, is it related to work? OSHA says that if you're in certain higher risk industries, generally not applicable to the participants of this call, healthcare industry, emergency response organizations, correctional facilities, in that case, then there's a presumption that the COVID was contracted at work. Otherwise, an employer needs to make a reasonable effort to determine whether the employee contracted COVID at work. And that would be sufficient in most cases to ask the employee how they think they got it, while respecting the employee's privacy, discuss with the employee their work and the work-related activities that might have exposed them to COVID, and then review the work environment. Have others been exposed? If multiple have been exposed, then perhaps that's a reason to make a report. If you don't, that's going to be one of the key areas leading into enforcement where OSHA has been bringing enforcement against folks. On this call, I think not doing your reporting, your record keeping, and a general duty clause violation are your greatest risk. You can see here on the screen there have been over 10,000 complaints about within the 27 non-state-led states, and it's resulted so far. It takes OSHA a long time to move. My general experience is about 5 months before they will issue a citation after they've been out to your facility. So out of those 10,000, there's only been 263 that have led to citations so far, but there's more and more in the pipeline. There's been about $3.5 million proposed penalty. The good news is there's a 6-month statute of limitations. So if you had an inspection at your place before mid-June, then you're probably in the clear. If OSHA does come knocking, what do you do? Certainly let them in, cooperate, but cooperate in a fashion that is protective of your rights. You have a right to insist on a certain process or procedure. You have a right to be present and to have counsel. You have a right to be present during certain interviews. The timeline would generally take about 6 months to complete, and then lead to an informal enforcement process where it would be given an opportunity in the first 15 days to resolve. If you don't, they'll file a complaint before the Occupational Safety and Health Review Commission. That process is moving very slowly. I'm working on a matter now where there's a fatality back in November of last year, not COVID, of course. We've just filed our answer the first part of this month because OSHA wants things delayed and slowed down. And with that, I'll turn it back to Kevin. Thank you.
Thanks so much, Eddie. Ladies and gentlemen, we have some emerging news for you. Many of you we know have operations in California, whether retail establishments, manufacturing facilities, distribution ports, warehousing, and so forth. California OSHA passed an emergency temporary standard specific to COVID-19 and what had to be done in the employment workplace. Yesterday, the National Retail Federation filed what we call a mandamus action against Cal OSHA in the trial courts in California, seeking an injunction preventing that from being enforced. And they challenged it on two bases. First, procedurally, the Cal OSHA did not observe the proper process in enacting the emergency temporary standard. And secondly, on the substance, that it was unnecessary and posed undue burden, both in terms of expense and practicality on the employment community. So I think we will all be paying very close attention to see how that plays out, and in other jurisdictions where these sorts of standards are being adopted as well. So let's go back now to Ali and see if we have any questions from our audience.
Yes, thank you all so much, Eddie and Jamila and Mario and Kevin. We did have a few questions come in. Our first question, do you expect most employers to mandate a vaccine?
Jamila, what do you think?
So I'll jump in. You know, right now I think it's just really hard to tell. I think a good number of employers will. I think it depends in large part on the industry and how the organizations are set up, and frankly, what's happening politically in a particular part of the country. I still think that may, whether it should or not, that may weigh in on whether or not employers mandate it. I think also too, given the rollout of the vaccine and the timing with certain industries, that by the time a particular industry is required to make such a decision, we may have a lot more information about response rate and vaccine rate and kind of just more data, because that for the general population, the timing is a little farther out. So, you know, I think all of that will affect whether or not employers decide to do so. But, you know, I think it's just hard to tell at this point. I would say a good number of employers will move in that direction. It's just hard to know at this point how many will actually do that.
Absolutely.
Ali, as the other employment lawyer, I agree with Jamila, and the clients I've talked to all certainly seem to be heading in that direction in terms of mandating vaccines.
Thank you. Next question. If a vaccine is not mandated, can employees refuse to return to the office, and can they continue to telework?
So the short answer to that question is no. But it depends on the circumstance, because outside of the circumstances that Mario and I both discussed, which are mandated or, you know, a legally recognizable disability or religious exemption that then entitles you to an accommodation, outside of those circumstances, an employee simply refusing to report to work due to the risk of COVID, that is not a recognized position that employees can take and still protect their jobs outside of the circumstances we just discussed. And that was actually the case before the vaccine, because we've actually had that question come up just over the last several months. You know, people aren't wearing masks, or my company isn't really enforcing the mask, and so I don't feel safe coming to work and I don't want to come to work. And that is not, the law doesn't protect your job under those circumstances, generally speaking, absent an accommodation or some other you know, similar or related issue. So it's the answer is probably not, unless there is a disability or some other circumstance that protects your ability to be able to do that.
Thank you so much. Next question. If OSHA standards are not met, are you allowed to require employees to return to work? Are they just suggestions or legal mandates?
Eddie?
Well, as far as, an OSHA standard, if it's really an OSHA standard, it's a mandate. If it's the guidance that we're talking about, then it is not a mandate unless something happens where the general duty clause may be pulled into play. And now, to give an example, the type of things that have caused that to be brought to bear, a lot of us are familiar from the news with the meatpacking industry and some particular facilities up north that experienced just pretty severe outbreaks within the employee workforce. That's the type situation that led OSHA to bring a general duty clause citation against an employer. But the guidance itself is decidedly not an enforceable legal standard.
Right, and it's important, as Eddie pointed out, to emphasize that while the guidance is not the standard, there are standards that Eddie identified for you that do apply to your workplace. And remember that it doesn't take much to initiate an OSHA investigation. All it takes is an anonymous phone call or email from an employee, and OSHA may be knocking at your door. So don't treat these things lightly.
Thank you. Next question. Can employers request documentation of a positive or negative COVID test?
So the most recent guidance doesn't really, the EEOC guidance doesn't touch on that, but generally speaking, if a person has been sent away because they exhibited symptoms or they've been exposed to somebody who has COVID, then the employer can ask the person to present a test in order to return back to work, the same as you would require somebody to present a release from their doctor or something similar if they were returning to work from an injury or something like that. Whether or not there is a dispute, the employee doesn't want to get the test or is fighting about sharing the results, those are issues that can be dealt with on a case-by-case basis. But generally speaking, the process that most of our clients implement is that if the employee rather has a reason to believe they've been exposed or they have symptoms, and the employer directs them to quarantine and get tested, they can ask them to submit a test result before allowing them to return back to the workplace.
Thank you. This next question is along the same lines. If you require employees to return, will you be liable to cover the cost of the COVID tests?
No. So, again, just like with anything else, and I equate it probably most closely to a workplace or some sort of injury. For example, if a person got injured, maybe they broke their leg playing softball and they have to go to the doctor, and through their insurance or what have you, they have to be able to come back and say that they can climb the ladder or do whatever it is that's required of the job. The employer is not required to pay for that exam. And so the same would be similar here for the COVID test. That being said, I do have a number of clients who are either sending employees to places to test where the testing is free or discounted. There are a lot, each county, depending on where you live, may have a free or discounted option. And so really trying to facilitate and work with employees to be able to cover that cost. But there's not a requirement that the employer cover that cost.
Thank you, Jamila. All right, this looks like it'll be our last question. Will employees with high blood pressure or other conditions that have been recognized as risk factors for COVID be able to request accommodation successfully?
I'll take that one, and Jamila, you can back me up.
No, go ahead.
Obviously, hypertension is a recognized medical condition, and any of the other high risk factors would be too. But yes, I mean, they can absolutely make a request for an accommodation. But again, that gets us into that interactive process between the employee and the employer, where a reasonable accommodation must be reached. And if the employer can show that working in the office is essential for that particular job, then working remotely is not a reasonable accommodation. Again, it's, as Jamila's pointed out repeatedly, it's on a case-by-case basis. Jamila?
Yeah, I agree with what Mario said. There's definitely no automatic accommodation. Just because a person presents with that condition, we can't say sitting here, yes, that person would be granted an accommodation or not. but certainly any medical condition that an employee thinks might entitle him or her to an accommodation, they need to make that request to the employer.
Thank you so much. And thank you all so much for joining us today for a wonderful presentation from Mario Barrera, Eddie Lewis, Jamila Mensah, and Kevin Mayer. If anyone wants to get in contact with our presenters, their contact info is listed on the final slides of this presentation. When you exit the webinar, you will receive an automated survey, and we would appreciate it if you would take 2 minutes to complete it. In addition, as mentioned earlier, we will be sending all attendees an email within the next 24 hours, which will include a link to the webinar recording and its slides. We hope you all have a happy, safe, and healthy holiday season. We look forward to having you join us in the new year for more SFIA webinars. Thank you all so much and have a wonderful day.
Thank you.
Thank you all. All right, gang. Well done.
All
Nice
right.
job.
Thanks, everyone.